Welcome to the second day of the Animal Law Symposium. My name is Caitlin Hawks, and I am the Chief Programs Officer for the Animal Legal Defense Fund. Just a couple of housekeeping comments before we get started. So first, all sessions today will feature closed caption subtitles. To enable this feature, click the upward arrow near the CC button at the bottom of your screen and select Show Subtitles. You can enter any questions you have into the Q&A box that you'll see at the bottom of your screen. I can't promise I'll get to all of them, but I'll endeavor to get to as many as I can. Also, the symposium is being recorded, and the recording will be shared with you later via email. Before we actually get started, we have a quick poll that I'll give you a moment to answer. If you're seeking continuing legal education credits for this session, please click yes. Attorneys seeking credit will receive information via email after the symposium concludes. Okay, great, thank you. On to the panel. So our first panel today will focus on transparency, First Amendment protections, and government accountability, all of which are paramount concerns for animal activists, journalists, and other advocates. Our panelists will discuss the obstacles journalists face in protecting their sources and reporting on animal issues, the role of FOIA activism in uncovering hidden truths, and recent legal battles fought to access public records important to animal activists. Our panelists are Will Lowry. Will is the founder and legal counsel for Animal Partisan, a legal advocacy organization focused on challenging unlawful conduct at farms, slaughterhouses, and laboratories. Will has handled numerous lawsuits as well as criminal and administrative enforcement actions against the government, industrial agriculture, and research laboratories, including cases involving federal slaughter laws, public records, false advertising, public nuisance, animal cruelty, and others. Next is Asher Smith, my former colleague from the PETA Foundation. Asher is Director of Litigation and Deputy General Counsel for the PETA Foundation. There he handles actions under the Endangered Species Act against roadside zoos, constitutional lawsuits on behalf of both animals and humans, and false advertising claims challenging the deceptive marketing of animal products as humane. And finally, last but not least, is Lisa Zeikerman. Lisa is Deputy Legal Director and Policy Counsel at Reporters Committee for Freedom of the Press. In that role, she supervises Reporters Committee staff attorneys and legal fellows, providing direct litigation and amicus support on issues affecting journalists and documentary filmmakers, including obtaining access to public records, access to court proceedings, and legal defense. As policy counsel, she also spearheads efforts to promote federal and state legislation on issues affecting news gathering, including anti-SLAPP measures, Reporter Shield, and government access. Full bios for all of our speakers are available on the symposium website. Thank you all so much for being here. This is such an important aspect of our work as animal advocates, and I'm just so grateful that you've taken the time to share your perspectives today. With that, we will launch into questions. I'm going to kick it off with a question that I'll first direct to Will, but others can jump in after that as well. This is a very foundational question. So, Will, why are public records laws and the ability to access government information so useful for animal advocates?
Thanks, Caitlin. Thanks for the intro, and thanks to ALDF for hosting this event. Yeah, I feel like sometimes public records laws, I wouldn't say they get a bad rap, but I've heard people say that they're boring or not exciting. And I think in many ways, people overlook some of the value of public records laws, whether we are talking about a state law or the federal FOIA law. And I would kind of list in my head, at least, the value of these as a number of different categories. I think first and foremost, there's just the principle of the government being held accountable for following the law. I mean, these laws were made to promote citizens to engage in the democracy, and the government can't just willy-nilly decide not to engage or follow these laws. I think one of the obvious benefits is around public exposure. These laws can be used in a lot of different ways to get information that would be valuable for the public to see as it relates to the treatment of animals, whether that's the conditions of animals in a lab, the government's role with animal agriculture, whatever the case might be. I think educating the public is a key value. I think there's also value in getting information as it relates to supporting legal actions. And so legal actions are founded on facts, right? You need facts to bring a case, you need facts to bring a claim. Sometimes you can use these laws to get that information. You know, you might not have known something was happening, the government was doing something, a university was doing something until you actually get those records. And now, boom, you suddenly see that there's a legal case that can be brought. Two last things I would say, you know, one, these laws are also good, or I found them good for engaging attorneys practicing in other fields. Many of these laws have the opportunity to collect attorneys' fees, and for small nonprofits like Animal Partisan, it provides an opportunity to get legal support without having to shell out that money if you have an attorney that can get attorney's fees in the event of a win. And then I would say lastly, and this is something that we're actually doing some research on, is there's some old science and studies out there about how people change their behavior if they know they're being watched, right? And so the premise is that the more records requests you do, the more you let somebody know you're watching, the better they will treat the animals. And so I think that's probably a value as well. But for all of those reasons, I think records laws are valuable, and we do quite a few of them.
Great. Thank you so much, Will. I'm going to turn next to Asher. Um, Asher, a feature of animal-related public records fights is often that they involve animal advocates requesting records from, in many cases, animal experimenters and institutions dependent on animal experimentation themselves. Can you discuss challenges this poses both to records requesters and to the process of litigating these cases where you have to fight in court to gain access to the records? What have you learned about how these institutions try to fight back against animal advocates?
Yeah, so how these institutions anticipate and respond to animal advocates, and also their just genuine fear of engaging with them, really shapes these cases. I'll start with one really stark example in successful public records litigation against Oregon Health and Science University. That was over videos of drunk prairie voles literally set up to fight in shoeboxes. That case started as an effort to obtain videos of these experiments that the lab claimed to delete it in their own words to keep them from falling into the wrong hands. After discovery, that case expanded to include a challenge to OHSU's police's practice of actually subscribing to intelligence style updates on PETA and other animal activists' activities. In that case, it turned out the wrong hands deletion was itself untrue. They actually kept the videos on the desktop of a lab computer, but that record was all instrumental in a win at trial on both illegal surveillance and records theories, and of a more than $400,000 penalties and fee award. Similarly, we've litigated a number of public records cases involving the University of Washington. In one of those cases, we saw videos from primate laboratories that experiment cited in publications. And to give you a sense of how the Primate Center approached their public records duties, they actually had a big no smoking style policy up, except instead of a cigarette, it was a crossed out camera to tell people not to take photos. That case, which also resulted in a more than $500,000 penalty and fees award, turned into a fight over UW's policy of deleting photos and videos without any log. So even their own experimental data to avoid animal activists getting them. Under the policy, Primate Center leadership had to approve any photos and videos that were kept. And the way this worked in practice is that experimental data don't have to keep that. That's a draft. But cute Halloween photos of monkeys with pumpkins, yes, keep that. Um, and in recent litigation we've had over efforts by University of Washington and University of Massachusetts institutional animal care and use committees that these institutions have to have that oversee these experiments. They've actually tried to claim a right to anonymity. I'm sure I'll get into this later, but that litigation finally, hopefully, ended for good earlier this week. Discovery really showed the length they'll go in order to stymie animal activists. For example, the extent to which they and national industry groups share information and narratives to support these cases, And in documents we obtained from UWI members earlier this year, the extent to which literally in their meeting agendas, they refer to all their critics or potential critics as animal extremists. This almost histrionic level of fear from the industry is both a complicating factor in working on these cases and also in many ways a big help. It's not unusual to have fights over whether nonprofit affiliated counsel or consulting experts will be able to access discovery, which in other litigation would be taken for granted. In the UW case, I actually faced a couple months ago a contested pro hoc vice motion, which is something I've never seen before in litigation against a credible counterparty. There because of the potential implications for access to discovery. And like I mentioned, I think that actually works to animal advocates' benefit. These are institutions that go into these kinds of cases with a lot of credibility, a lot of prestige, but they can lose it quickly by taking what judges might see as very silly legal fights, like fighting over a pro hoc vice motion that require the courts to adopt their paranoia about animal activists very early on in the case without even the help of a factual record.
Thanks, Asher. I'm going to turn next to Lisa. Um, Lisa, the Reporters Committee is a leading pro bono provider of legal services for journalists seeking access to information. What are some of the most common access areas that come up in your work?
Thanks, Caitlin. I'm really honored to be part of this training, this symposium, knowing that many of our participants today are journalists and some may not be. But the Reporters Committee's resources focusing on transparency can be useful to anybody who's looking to hold their government to account and get access to records. And we've shaped our materials, our guides, and our online tools for the common areas of access that journalists typically want to avail themselves of, but anybody, regardless of whether or not you're a journalist, can certainly use our guides and materials. We focus a great deal on breaking down public records access laws state by state, rather than focusing merely on federal FOIA. And I would suggest, especially in an age where our federal FOIA could use a lot of work and is very much an overwhelmed system, there are a lot of state-based records that could be useful to anybody who's trying to learn more about what their government is up to in the animal rights space and anywhere else. So on our website, we have guides that break this information down step by step. How do you make a request? What do you do with respect to exemptions that the government may raise that would, according to the government, foreclose access to otherwise public records? How do you bring an appeal? And how do you bring litigation if necessary? All of those resources really, to our minds, are paramount for most of the journalists who contact us for assistance. We have a 24/7 legal hotline that's available for working journalists and media lawyers. And I will tell you, the predominant area of inquiry is public access to public records. I would say the next sort of rung down is access to court records. Whether or not you may see it as sort of public access, it is a major part of our public access regime as a nation. Most judicial records are open to the public and should remain open to the public. And to the extent there are private actors or state actors and private actors engaged in litigation that touch on issues that are of importance to you, to the extent any of those records have been sealed, there are legal avenues to seek to unseal improperly closed records and proceedings. And we have a lot of information and guides on our website, again, breaking down both federally and state by state how to go about seeking access to improperly sealed records.
Thank you, Lisa. I'm going to pivot back to Will and ask about a specific matter. Will, Animal Partisan recently sued the FBI over public records. Can you talk a little bit about that case and what you discovered there?
Sure. So the premise of that case is just a desire to support grassroots activism. And so we believe that's an important part of the animal rights movement. And so as part of that, we had done some records requests to the Federal Bureau of Investigation just to look into various interactions with the animal agriculture industry And one of those was specific to a conference, an agriculture conference that was held in 2020 by the National Meat Institute. And we had found out that the FBI had presented at that conference. And so obviously wanting to know what the FBI is doing at a agriculture industry conference, we dug deeper and did records requests. The case has gone on for probably 2.5 years now. It's not quite finished. But the FBI's initial response was there are no records, which we knew not to be true. We knew that the presentation had happened. And so we pushed back on that. And eventually the FBI came back and said, yes, we have records, but this relates to an ongoing law enforcement investigation. And we can't release them because of an exemption. We found that odd because this was a public presentation to hundreds of people. So if they're worried about an ongoing investigation, you would think that they weren't presenting to an audience of agriculture people. So we did an administrative complaint that was denied, and we ended up suing. We were and have been represented in the suit by the Sorensen Law Office and the Vermont Law Farm Animal Clinic. And we ended up getting the records that we sought. It took quite a bit, but what the records revealed was what I would classify as kind of an escalation in tactics of the FBI targeting animal rights activists. And it showed that the FBI was speaking to the agriculture industry about ways to use federal weapons of mass destruction statutes against animal rights activists. And you might wonder, well, what does that look like? And the premise behind that is we have statutes that prohibit things like biological warfare. And, perhaps there's a case where activists go on a farm and then suddenly someone claims that there's a biosecurity issue. Now, can they charge the activist? And some of these statutes have penalties up to life in prison. And so we discovered those, we shared those, kind of back to my earlier comment about public exposure. This story was picked up pretty widely. I think it helps paint the picture of government oppression of peaceful activists. And so that case is still ongoing. It's at the attorney's fee stage, but we won the case and we got the records. And so like I said, I think that's a great example of revealing information that's very helpful for public exposure purposes to show what the government is truly up to. And in this case, how they're collaborating with the animal agriculture industry.
Thanks, Will. Just a follow-up question with respect to how these public records law mechanisms work, that someone in the audience asked, which is public records access like this only for lawyers and journalists, or can any member of the public make a request under these laws?
I
I mean, go ahead, Lisa.
Anyone can make a public records request. You don't have to be a lawyer. And in fact, you can also bring any stage of your appeal all on your own. And I do recommend working with attorneys if you're going to file anything in an actual court. But seeking public records is a right that all citizens hold.
Thanks, Lisa. I have another case-specific question, this time for Asher. Asher, before it was dismissed earlier this week, actually, you were engaged in a close to half-decade-long battle over efforts by members of institutional animal care and use committees, including at the University of Washington and the University of Massachusetts, to keep their identities out of public records. Can you provide us a bit of context on why those identities are so important to animal advocates?
Sure. So any institution, including public universities, experimenting on animals is required to have an IACUC, like it said, an Institutional Animal Care and Use Committee. These committees are responsible for ensuring compliance with the Federal Animal Welfare Act and also National Institutes of Health animal welfare policies. These regulatory regimes governing animal experimentation rely largely on IACUC self-reporting, as do a number of regulatory regimes. Multiple Inspector General reports have explained the inadequacy of this process, including USDA inspections, which also cover things like zoos. So if an IACUC is operating as a rubber stamp or otherwise not performing its duties properly, which are both paraphrases of observations the government has made about the University of Washington, animals will suffer with basically no accountability. And while I'm sure a number of animal advocates watching today might be justifiably skeptical of the stringency of the laws under the Animal Welfare Act and other sources of law that these committees are charged with implementing, the actual rules they're supposed to enforce would be quite transformational if you took them seriously, or the way that animal activists would prefer they were interpreted. Just one example, IACUCs are required to demand documentation that alternatives to painful experiments were considered. So an IACUC that was actually determined to enforce the law as written would do a ton of good. And that's who federal law suggests should be on these committees. Under federal law and regulation, IACUCs are supposed to include, for example, a non-scientific community member, meant as elaborated in later guidance to represent a scientifically naive perspective is the actual word used. And examples given include an ethicist or a clergy member. They're also supposed to include non-affiliated committee members, which federal rules suggest means no discernible ties to the institution, which sounds pretty clear on one level, but actually PETA understood through public records that UW had given these positions to people who had previously worked at UW, whose spouses have worked at UW, who were donors to the university, who experimented animals themselves. And in one case, as the non-scientific member, actually the executive director of a major animal experimentation lobby group. In a reply brief in an affidavit they attached, the IACUC chair actually confronted these arguments head on and actually just admitted that her view is that no discernible ties somehow means that recent university employees are kosher non-affiliated members. This perspective on how IACUCs work is actually really core to the eventual outcome of these cases. When the IACUC members filed their lawsuit, they tried to make the case all about the idea that animal advocates wanted to know who was on the IACUC so that they can go and protest at their homes, which, even though it's constitutionally protected, this was a time when home protests of federal judges was a major news story and something that I imagine most federal judges would be very attuned to those concerns. What we successfully did in our submissions was basically reorient the case around what IACUCs are, what they're required to be, and why member identities are so important, why it's so important to know that IACUCs have people who fit all of these roles, and get the courts to understand that transparency can serve a serious public interest, and that current regulatory or voluntary certification schemes aren't substitutes for that public interest.
Thanks, Asher. We had an audience question related to IACUCs, which is just who is charged with policing them, or is there anyone responsible for that?
Sure. So there's two sources of oversight, somewhat, of IACUCs. One would be the United States Department of Agriculture, the Animal and Plant Health Inspection Service. It inspects laboratories kind of the same way that inspectors would inspect a restaurant, except it happens once a year, if that, and is a pretty light touch. The other is the National Institutes of Health has policies out there that these institutions are supposed to aspire to reach and essentially have to report their own violations. That's a lot of it, although a very interesting wrinkle was that in the first iteration of this case, plaintiffs made a great deal of the fact that actually the University of Washington also pays for its own private oversight of their laboratories and IACUC committees' work, a group called AAA-LAC. And that so actually seemed to confuse our first district court judge that he actually cited that as a source of government oversight and was the subject of a very compelling amicus brief from the Animal Legal Defense Fund explaining why private oversight should essentially be considered equivalent to nothing. And thankfully, after that first appellate win at the Ninth Circuit, that's not an argument that reared its head again.
Thanks, Asher. Turning back to Lisa. Lisa, what are some trends the Reporters Committee has seen in recent years in the access space? and especially in the recent months of this new administration?
Been a busy few months in the access space, especially in federal FOIA. Trends that we've seen for a while are legislatures and courts getting accustomed to the importance of data journalism and access to large data sets. Some states and state courts have really recognized that, as opposed to some areas of public records law that exempts or protects in some ways the government from having to create new records in order to satisfy a records request, that requests for large sets of data that are housed by the government does not fit squarely with that case law and is instead fully protected by most state access laws. In other words, some governments have resisted requests for large data sets, claiming that in order to fulfill those requests, they would need to aggregate or otherwise perfect the data in order to satisfy a public records request. Data journalists have pushed back hard on those kinds of that resistance and pointed to the fact that most data exists in its own native form and doesn't require additional government creation and doesn't quite fit into that sort of create a new document doctrine in the public records space. So that's been a long-term trend I thought would be valuable for this audience to know about. I will also say that there's a renewed interest in seeking access not just to documents, but to public bodies and their meetings. Every state has sunshine laws that dictate when public bodies can meet and the extent to which those meetings have to be conducted in public. I think the pandemic laid bare some of the true enormous challenges of providing ongoing access in virtual spaces. And so there's been a renewed interest in litigating and protecting that access as the pandemic has lifted, and more public bodies have continued to either try to meet with limited public access remotely, or have had difficulties continuing the tradition of public access in public spaces. But that's a trend that we've been following very closely. We've been involved in a good deal of litigation state to state. The other thing I would point to just in more recent history is, I mentioned earlier, federal FOIA is a really difficult system to operate in, not least, has been for a long time. There are tremendous backlogs in various agencies in responding to FOIA requests, a trend that has forced us to advise a lot of journalists to file suit in most FOIA actions, because once you file suit, you will get a production schedule from the agency that may help you at least get some documents, even if there are areas that will need to be litigated. And from an advocate's point of view, or from a journalist's point of view, if you're making a public records request and it's denied or effectively denied because it hasn't been responded to by an understaffed agency, you can appeal in federal court and you can bring a claim. But you may not have to immediately rush to the merit stage of your claim. And most courts, especially in the District of Columbia, where the federal courts have a lot of expertise in this area, issue orders requiring production schedules from the agency to start to meet their obligations to respond to your request. And that is one way of ensuring that you actually do obtain records, and rather than being sort of stuck in a bureaucratic hole. Another trend that we've seen, though, is that as a result of backlogs in the federal FOIA space, a lot of journalists have found creative ways to use state public records regimes to get access to records that they assume only exist in the federal government. And I thinking creatively on the spot right now, to the extent, activists are looking at state agriculture and their relationship with federal authorities. Most state public records laws are not preempted by federal law or other federal secrecy statutes. And you may find that you have better access to data that you want about state level agricultural industry than you would through federal FOIA. And you might get resolution of those claims, to the extent there's resistance, far quicker in state court. And then lastly, I just want to point to, we talk about how difficult federal FOIA has been for a long time. Now we're in an age where federal FOIA offices are being decimated by orders to ramp down and put on admin leave federal FOIA officers. I think a lot of folks on this call may be aware of the stories that broke a couple weeks ago, or maybe a month ago, that HHS, in fact, had laid off most of their federal FOIA employees. And we're in active litigation with a component of HHS in a federal FOIA case. the AUSA representing the agency in that case essentially told us they have no client right now in the federal FOIA office. And they went to our federal judge overseeing that case and asked for forbearance on an existing scheduling order to move into summary judgment in that case. We resisted and opposed, noting that, among other things, a lack of staff doesn't absolve the agency of their obligations under federal FOIA. We also pointed out that while it had been reported that HHS has engaged in a reduction of force, so to speak, it has not put on leave the FOIA personnel in the FDA who are working right now to meet litigation deadlines in a FOIA case brought by the HHS secretary's former attorney, a case that would appear to align with the secretary's own policy goals around vaccine regulation. This was actually reported in Kaiser Foundation's website. You can go take a look at that reporting if it's of use or help to you. But it was very persuasive with the court in our case a few weeks ago, who entered a minute order that essentially says, the failure of Congress to appropriate funds sufficient to meet an agency's FOIA obligations is one thing. It's another thing altogether for any agency simply to decline to expend the funds that Congress has provided, and essentially told the AUSA in that case, it is no excuse that there is no FOIA staff for you to litigate this case. The defendants, quote, stand forewarned that the court expects them to comply with their obligations under FOIA and the court's orders, and they may not evade those obligations by dismissing FOIA staff needed to do so. In other words, the courts get it. They're overwhelmed with litigation right now related to this current administration, in particular, the district court here in the District of Columbia. But I just wanted to share that piece of information. And the last thing I would say in terms of trends is that reporters are constantly looking for information and sources for information. Sometimes federal FOIA can be useful just to figure out who your best source is, especially after a recent change in administration. And a lot of reporters are lodging very simple FOIA requests. Tell me who works at this component. What is their role? How do I contact them? And then as soon as they get that information, they can rock and roll and do a lot more source work and information gathering that doesn't require wresting documents out of a resistant or understaffed agency.
Thanks, Lisa. And we had another just kind of basic FOIA mechanics question from the audience, which I suspect any of you could answer, but just what is the cost of submitting a FOIA request and getting records, and how is that determined?
There may be different costs state to state, but for the most part, you wouldn't have to pay money out of pocket just to make a request. What you're really looking at is if you have to file a legal claim, usually there are costs associated with initiating a legal action, and potentially if you're represented by counsel whom you have to pay for, you would have to pay for their fees.
And I think that in making FOIA, I mean, there could be costs associated with like searching for and printing documents, but if you are a nonprofit, you can ask for fee waivers. And generally speaking, there will at least be a significant reduction in fees in response to a request along those lines, I think. Okay. Coming back to Will, Will, you mentioned in discussing the last case that I asked you about that the FBI had undertaken efforts to target animal rights activists. Have you encountered other situations where law enforcement collaborated with the animal agriculture industry?
We have, and I suspect others have as well. I think that I'm kind of fascinated by that intersection of the animal agriculture industry and law enforcement, not just at the federal level, but at the state level. And so we have seen interactions that I would say are a bit troubling, but not surprising. I can give you a few examples. I would say at a high level, we do a lot of requests for dash cams, body cams, right? It's nothing better than to see a video and see exactly what's happening versus somebody's articulation in a document. And so, as one example, we do a lot of records requests related to livestock truck accidents, just looking into the aftermath of that, the interaction between law enforcement, first responders. And it's a little surprising to say, but I've seen 3 times in 2 different states in the last year and a half where law enforcement has sort of, at the request of the agriculture industry, pushed the media away, prevented videos and pictures, often mentioning that we don't want this information to get to the animal rights activists. You know what they're going to do about that, et cetera, et cetera. A couple of incidents in those same accidents where law enforcement was actually mistreating the animals. So we had a piglet truck crash in Ohio with about 1,900 piglets, and there was a law enforcement trooper that was hitting piglets with a baton, throwing them. You know, we have one that we haven't released yet, which is full-grown adult pigs after an accident, just the most horrible suffering, you know, being shot by state troopers. So we've seen that and that sort of collusion, I would say. We've had other stuff where we submitted complaints regarding a slaughterhouse, for example, you know, arguing that cruelty was violated, and then looked into the body cam of law enforcement's visit to that slaughterhouse and saw things like, you know, the officer saying, "This is a stupid complaint. I don't know why I'm here," and sort of coaching people on what to say. And so that's not to say that law enforcement all over the place is doing these things, but I would say we've seen a lot of a high frequency of troubling issues. And I guess for people looking to use public records laws, don't forget about those interactions between law enforcement and agriculture industry contacts. It is certainly hard with things like ag-gag laws and others to get a glimpse into that industry and where we can see that industry interacting in a way that's going to be captured on video, whether that's body cam or dash cam. I think I think it behooves us as activists to go after that video.
Thanks, Will. Um, Asher, the decisions courts have entered in connection with IACUC transparency are often full of lurid details about animal advocates. There are references in there to actual and threatened reprisals against companion animals, Nazi comparisons at public meetings, various threatening emails. Last December, the University of Washington IACUC actually canceled its monthly public meeting, citing alleged safety concerns. Have you investigated the factual arguments IACUC members use to support their argument that they face real risks if their names are made public?
Absolutely. This is an aspect of the case that we've spent a lot of effort rebutting. We've investigated each and every example that committee members cited in support of their argument that they face a deluge of harassment and intimidation, and how quickly these stories fell apart, I think illustrates what I mentioned before about the degree of institutional fear of animal advocates at issue. In their lawsuit, the plaintiff committee members suggested they were threatened by a member of the public, calling them basically sadistic Nazis during a public meeting. And while as a lawyer, I'd like to believe the cases that are out there literally holding that you're allowed to call public figures Nazis, it's protected speech would be enough. But we had to cover all our bases. So we went to a video of that meeting, and it actually turned out that the speaker was a kind retired UW professor who respectfully used his 2 minutes to recite a famous aphorism from a Nobel laureate refugee of Nazi Europe, Isaac Bashevis Singer, who I'm sure some of the audience members are familiar with, to the effect that to animals, all people are Nazis. For them, it's an eternal Treblinka, which folks are entitled to agree or disagree with, but that strikes me as a model of how this kind of public government meeting is supposed to work. We made contact with that professor, we submitted a declaration from him, and then we actually got a counterexample because they seemed to think that example was much weaker now. A declaration from the committee chair came back and said, well, another example, unnamed member of the public calling us Nazis, and also mentioned the name of my cats to intimidate me, suggesting that this unnamed person used some kind of nefarious means to hunt down the cats' names. I was kind of at a loss as to what this was a reference to, so canvassed the resources I had. I asked the retired UW professor, did you see this? Do you know what happened? Turned out it wasn't an unknown member of the public, it was him again. And not only was this a polite exchange, he didn't search out the cats' names, he knew the cat's names because he and the committee chair were having a pleasant chat before the meeting, at which she told him her cat's names. Another companion animal related example, just because somehow there's so many of these. One anonymous IACUC member actually said in a declaration under penalty of perjury, I think, that they were aware of other IACUC committee members having pets kidnapped. We call that out in briefing as a totally unsubstantiated urban legend. And finally, in the third iteration of that case, back down from the Ninth Circuit again, plaintiffs did sneak in an acknowledgement in another declaration saying, well, that claim, that one's retracted. That was basically an urban legend that we fell for. Oopsies. I think this speaks to a really interesting aspect of litigating cases against this industry, though, from an animal rights perspective. I mentioned before that these are institutions with a lot of credibility. It takes a lot to make courts skeptical of them. And for years of litigating various cases against these institutions, mostly in the public records context, courts, even when they rule in our favor, don't always want to engage in the factual back and forth about who's right about what. What finally broke through, though, in our fourth and final fight against a motion for a preliminary injunction in this saga was a Slack message we found in an expedited pre-answer round of discovery we did to ensure there would be no surprises, in which the committee chair said something to the effect that a new email that UW received that led to that meeting cancellation. The email was essentially an incoherent request by a member of the public asking for the IACUC roster. She actually said, oh, well, this makes me a little scared for basically the first time. That private admission, after years of litigating anecdotes relayed by that same IACUC chair in declarations submitted to the district court, really got our judge's attention and is actually something that he quoted. And we finally got a judicial determination after all these years that there were no facts that could amount to irreparable harm or could go to support an injunction.
Thanks, Asher. Turning back to Lisa. Lisa, what can journalists do about government regulations and court orders that leave public employees speechless? Are government gags of employees constitutional?
So folks may have heard there are a number of policies that have been adopted by governments, both federally and at the state level, and even the local level we've seen, essentially requiring that public officials and public employees never speak to the press or outsiders, and so that the agency can only speak through their public information office, their PIOs. This is a really frustrating retrenchment on transparency. So imagine you are trying to seek information from government, either informally by making requests for data or information or records, even if to the extent that you can obtain them through a friendly source, and suddenly that line of communication is shut off. There have been a couple cases challenging these so-called gag orders on the ground that where you have government officials or public employees who are willing speakers, any rule that limits their ability to talk about their work outside of work is an infringement on their First Amendment rights. One case in particular, we brought in Allegheny County, which is in Pittsburgh in Pennsylvania. Nurses and other staff of a prison in Pittsburgh that was notoriously underfunded and had severe health consequences for a lot of their inmates, including death. Many of those employees wanted to talk with reporters who wanted to cover that particular prison and its conditions, but they were precluded from doing so based on a gag rule, and precluded from sharing documents, information, a lot of other information that would have otherwise freely flowed between these government sources and interested, inquisitive members of the public, including the press. We filed a federal lawsuit challenging the gag order, and the state settled with us, changed the policy, in fact, revoked it almost entirely, and it no longer prevents its public employees from speaking with members of the press or the public about the work that they do. And so I raised this issue because oftentimes when activists or others who are reporting in the animal rights space want to reach out to government officials, if you run into one of these gag rules, there are opportunities to file suit. There are other cases that have gone further than ours, and we're bringing more, but just wanted to highlight this area of the potential legal challenges.
Thanks, Lisa. Turning back to Will, we've covered a bit of this in responses to various questions I've posed already, but what are some other common obstacles encountered when trying to obtain records from the government regarding use of animals?
I mean, there's kind of a litany. It almost sometimes seems like a menu that the government agencies are working from to try to obstruct access to the records. One that we run into a lot is just sort of a flat out denial that there are even records that exist. So we don't have records. Like I mentioned in our FBI case, that was the first response, even though we absolutely knew that there were records. So a flat denial, which is often difficult to get around, right? It's kind of hard to prove a negative. It's hard to prove that records exist when you're being told that they don't exist. There are many, many exemptions in, state public records laws, as well as, the federal FOIA. And those exemptions kind of run the gamut, and they cover lots of different things, whether it's pending investigation or trade secrets or personal privacy type stuff. That is certainly an obstacle to get around. I think from an advocacy perspective, at least my 2 cents is you have to take each one of those head on, right? Every exemption has a different rationale, has a different cases, different legal justification. So some of those can be worked around. Fees, there was a question earlier about fees, and Caitlin, to your point, like, yeah, it doesn't cost to submit a request, but it certainly can cost to receive records. The publication or the review of the records at the federal level, the federal FOIA level. I think, as you mentioned, if you're a nonprofit, it's not terribly hard to get those fees waived. We often encounter this at the state level where it's, this is going to cost. Asher's talking about IACUC. We've gotten $10,000, $12,000 estimates for IACUC records that you think would be very basic and easy to obtain. So that's certainly an impediment as well. So I would say that those are kind of the big things, and there's varying approaches to getting through those. I think the exemptions, you just have to dig into each one, see if there's a legal arguments. With the fees stuff, you can try to narrow your scope, you can try to dispute them, but those are some of the big obstacles that we see.
With respect to fee estimates like that, particularly in response to state public records requests, do you suspect that at least some agencies are trying to use those fee estimates as a mechanism by which to keep records out of, to use the quote from the OHSU case, the wrong hands?
Yeah, I mean, I have no doubt that that's sort of a lever that is often pulled, and I think the justification for that statement would be sometimes if you ask for a detailed breakdown of what is required for these, and you get 3, 4 levels of review, senior level people, and that these are rudimentary documents that don't require all of that. And it's very difficult, at least in my experience, to sort of challenge a high fee estimate. And so short answer is yes, like that's been my experience, is that this is a tactic that's being used to keep these records from the public eye.
Yeah, I suspect the same. And I also have always been curious, though have never really undertaken a study to explore this, but what would happen if you had similar requests submitted by different parties who hold disparate viewpoints, to see if there actually is like an evident viewpoint discriminatory kind of practice there with respect to the fee amounts that you're being quoted. My guess is you probably would find that there is, at least in certain circumstances when you're dealing with certain government agencies.
For my 2 cents, I'll say I represent news media, and to the government actors who present these overblown budgets for production of records, their biggest concern is transparency, right? It's just exposure. So if it's viewpoint or not viewpoint, I would just be in the lane of, it may not be viewpoint, it just might be a complete resistance to transparency.
Yeah, that's an excellent point. a sort of semi-related audience member question just about the kind of basis for withholding these documents. Have you guys dealt with withholding on the basis of trade secret or intellectual property based objections? And how do you navigate that?
Yeah, so we did see that in our University of Massachusetts litigation. They tried to argue that a number of experimental records we requested should be exempt under trade secret protections in Massachusetts PRA law. And what was funny there is that the way that we would learn about the existence of these records in the first place would be that they describe the kinds of data that exists, or they describe the experiments in great detail in academic publications. But it's an interesting, on the one hand, tails, we win. On the other heads, we also win, where they get to cite all this stuff, explain how the experiments work when it benefits them, when they're, speaking to their own community. But then when it comes to a member of the public or a nonprofit requesting the same information, well, this stuff that we were just making public, that's actually a trade secret. So that often is the kind of thing we have to litigate. And often that litigation involves having to point out, but you just said X, Y, and Z in this publication that anyone could go access.
Thanks, Asher. Staying on the topic of improper withholding. So, IACUC members are definitely not alone among government officials in working on controversial subject matter or in wishing to remain anonymous. So, for example, providers of abortion care and researchers involved in fetal tissue donation have sought and won court orders to keep personally identifying information out of the hands of their perceived adversaries. Can you explain what tactics and legal arguments IACUCs have tried in order to support anonymity?
Sure. And in the non-litigation or pre-litigation context, this often means things like we were discussing earlier, things like essentially intimidating staff into not taking photos and videos, or making it clear the culture is one in which that doesn't happen. We don't create records. In the IACUC context, it's actually meant, and this is why our litigation eventually revolved around appointment letters to IACUC members. It meant overwriting the actual roster documents and treating them as what they refer to as living documents. This is all to avoid an obligation to produce documents. As Lisa was mentioning earlier, there's typically no obligation under public records law to create new records. So if you could engineer a situation in which IACUC records or other kinds of public records won't exist at all, you're sadly kind of in the clear. During public meetings, be careful about using names, adding more process and limitations to who can participate in public meetings. And then on a legal level, in our UW litigation, the IACUC plaintiffs began the lawsuit with one claim. They tried to argue there was a First Amendment freedom of association or academic freedom problem with not having anonymity. Thankfully, that's one issue the Ninth Circuit agreed with us on, explaining that these kinds of associational rights can only be claimed by groups actually engaged in expressive association. And that's where the actual laws and regulations governing these kinds of committees become so important, because we were able to explain by reference to the regs themselves that the association here is not about advocating views, pursuing any kind of personal interest. It's literally exclusively about fulfilling federal law. And as the court pointed out, under these regulations, they're actually barred by federal law from taking part in any kind of academic inquiry or decisions about what to experiment and why. After that, with the First Amendment arguments gone, we saw a new constitutional theory, informational privacy law. The argument here was kind of circular. They take some steps to keep this information hidden. Therefore, it should be considered private and not subject to disclosure if they could allege a risk of what they refer to as harassment. This is another area where we got the Ninth Circuit to see a clear distinction between trying to protect something like Social Security numbers or other kinds of intimate details, and literally just basic biographical information. Well, to date myself a little, you'd find in a phone book. And again, the fact that someone's name is tied to their government service was important here. We also actually got some help from the fact that one member of our Ninth Circuit panel, Judge Lee, reached into the factual argument a bit and commented a few times during oral argument that it seemed like these examples of harassment were all references to protected speech that he described as more or less the price of public service. So going back down below, we definitely made a great deal of citing to oral argument, citing the fact that a member of the Ninth Circuit already glanced at the facts and said, come on here, more or less. Another interesting aspect of this inquiry also was, what examples can you use to show a culture of harassment, to show that there's a context where you might find an informational privacy right? Plaintiffs, I mentioned before how well connected and plugged in they seem to be to the wider industry, basically canvassed the country for experimenters who got mean emails. So part of what we did at that point of the case was building an affirmative factual case around the experimenters who got the mean emails, who they cited, to explain that these are actually, within their context, public figures. They're faces of animal experimentation, they're faces of their laboratories, and they put themselves out there front and center in the public discourse and as recipients of a heck of a lot of public money. One last ditch argument we actually saw also was preemption. This was an interesting one. An argument that an NIH policy that allows IACUCs the option of keeping most member names out of regulatory materials means that there's a preemption issue with disclosing this stuff under public records law. Here, we succeeded in pointing out that this is optional and that there's even another Washington state institution governed by the same Public Records Act that had a fully public IACUC. I saw in the chat a question about litigating against private IACUCs, even though the kinds of laws that they're charged with enforcing tend not to have private rights of action. That context was very important here, actually, because in helping the Ninth Circuit understand what's the significance of the fact that there is this optional privacy regime, part of what we were able to explain is that, well, you have to understand there are both public and private IACUCs. It's the public IACUCs that have these disclosure obligations, and for the private IACUCs where these kinds of privacy interests may become more apparent.
Thanks, Asher. Lisa, can you just give us some information on what the current status is of DOJ guidelines and the proposed federal SHIELD law?
Sure. So I wanted to also mention to this group, especially to the extent that you engage in journalism or activism, you may also be the recipient not of records that you requested and obtained from the government, but of leaks of records or information through government actors. And in the journalist space, there are some recognized protections for journalists who receive information obtained, even if it was obtained unlawfully by others, but let's just focus squarely on government officials. If you receive leaked information, the sources of that information may be protected under state law that recognizes a shield for reporters not to disclose their sources, their confidential sources, or even unpublished, in some cases, materials that they may have received but haven't yet published. But in the leak space, especially at the federal level, there's been a lot of discourse with this new administration about going after leakers. And with that also comes going after the recipients of leaked information through compulsory process. We've seen that in the journalism space, in alarming different kind of formulations over the past, let's say, 15 years or more. For a long time, the Department of Justice has had in place particular guidance for their line prosecutors that require them to provide notice and get accelerating approvals for compulsory process of information from journalists, including approvals from the Attorney General. And this is a recognition of the important role that the press provides and serves to the public in disseminating information, even leaked information. Under former Attorney General Merrick Garland, those rules were were further shored up as a result of the advocacy of the news journalism organizations. But just last week on Friday, Attorney General Pam Bondi issued a memo to all U.S. Department of Justice employees titled Updated Policy regarding obtaining information from or records of members of the news media. Those regulations were promulgated yesterday. We're still digging through them. For anybody who's ever followed this issue, I'll just say simply, the regulations now reflect closer to what they used to look like under former Attorney General Eric Holder. And there is some concern about rollbacks of safeguards for journalists who may receive leaked information. But putting that aside, I just talked briefly about state level shield laws, these particular guidelines at the federal level. What do we do at the federal level with respect to a shield law? The Press Act is the legislation that would establish a federal shield law for journalists. It has come through Congress multiple years in a row. We advocate very strongly for its passage. But after a huge push last fall, it was not passed by last Congress. I expect it to be reintroduced this year, but the opportunity for it to become law, even if it gets through Congress, is probably very low, because I do not expect this president to sign into law a federal shield law. So all of this to say, to anybody on this call who is the recipient of leaked information, the Reporters Committee provides a lot of legal advice and guidance to reporters who find themselves in that position. And it could be very delicate. It could be very fact specific. And I wanted to raise that issue with this audience as well.
Appreciate that. Thank you, Lisa. Turning back to Will. Will, do you encounter any different obstacles when obtaining information or attempting to obtain public records information about animal research as opposed to animal agriculture?
Yeah, I would say there's a few different things that have come up. And this is just my experience, but when we talk about research, a lot of our requests are going to universities. And so there are different things that come up in that context. There are educational student privacy laws like FERPA at the federal level that you will often see invoked. If there's a research study and there are students, doctoral students or whatever engaged in that, that often comes up. So that's an obstacle. I've seen, I would say, quite a few lately using like veterinarian confidentiality related exemptions, right? So if we are doing something with an animal, then the argument goes, this is a veterinary procedure. We can't give information without the owner's consent. I think some of those are a little dubious. We're challenging one in Kansas that Kansas State University brought up, where there really weren't any veterinarians involved in the research with any substance. And then, I would say I've seen some states, I think it was Indiana recently, that just had this very blanket exemption for research. I mean, some are research until the point where it's published or some other condition that has to be met. There are a few states where the exemption is just very, very broad and covers research kind of at a blanket level. So I'm not sure what others' experiences have been, but I'd say I'd seen a few more unique exemptions or obstacles in the research space than the agriculture space.
Thank you. I wanted to pivot back to an audience member question that came up earlier in response to a comment that Lisa made with respect to the ability to challenge improperly sealed records. And an audience member was just wondering how those records were or why those records may have been improperly sealed in the first place. Lisa, can you just explain a little bit about how that might come about?
Sure. I mean, let's just talk about civil litigation in the first instance. A lot of times civil litigants exchange information, as we've referenced before, in the discovery process, and oftentimes they want to do so with some protections. If they're disclosing to one another what any one party considers to be confidential or highly confidential information, they may introduce and have approved by a court an order that is oftentimes referred to as a protective order, or a stipulated protective order that allows the parties to exchange that information with some protections that it not be revealed outside of the litigation and outside of the attorneys involved even. That would be considered AEO, or attorney eyes only. Oftentimes the standard for a protective order to be adopted is just good cause, and good cause is a very low standard. It's a party basically saying, I have, key business interests in some of these records. I have some concern about trade secrets. I have some concerns about proprietary information that I don't want to be disclosed in public filings, or I don't want the party who's receiving this information to treat it except with the utmost care and secrecy. And that can be easily adopted by a court. The problem is that most judicial records have to be public. It's a First Amendment principle of high importance. But yet parties who have already adopted a protective order to govern their discovery may use that protective order to continue sealing materials that they otherwise need to file in the case, either during motion practice over discovery disputes or summary judgment potentially. And unless there's a party, an outside party, willing to come in and challenge that sealing, if a court hasn't otherwise taken a hard look at the sealing that may be done by parties pursuant to a protective order, we see a lot of dockets across the country in federal and state courts with innumerable sealed records that should never have been sealed. Because the standard for sealing in most judicial records is far higher than good cause. But when the parties have already created sort of I call it the SOP of secrecy, right? That they have a permission to file things provisionally under seal, potentially under their protective order, everybody just kind of lets that ride. And so oftentimes you may be interested in the outcome of a case. You may think there was interesting discovery that was shared in a case that may have ended up being lodged with the court, particularly at the summary judgment stage. And you might go into the docket and see that most of that material was sealed. A third party can move to intervene in that proceeding for the limited purpose of seeking to unseal records that were improperly sealed, and ask essentially for the court to require the parties to meet the higher standards that apply to judicial records for sealing.
Thank you, Lisa. I have sort of a catch-all question that I think is mostly for Will and Asher, because I think just some additional examples might be useful for folks who are interested in obtaining records using some of these tools that we've talked about today. Can you guys just give some other examples of the types of records you've obtained and how they were useful to animals?
Go ahead, Asher.
Yeah, I mean, right off the bat, I think any kind of experimental data is probably memorialized in a record somewhere, or at least should be. There's a National Institutes of Health policy that experimental data needs to be kept for at least 3 years. Other industries as well. I would just keep an eye out for what kinds of materials are being mentioned in public resources. For example, we've had a lot of success scouring publications that describe the records used, and this is all enormously helpful in making what happens for animals at these institutions real for the broader community. I think the first case I mentioned today was literally a case where prairie voles were given the equivalent of 15 bottles of wine and then thrown in shoe boxes while experimenters literally recorded them fighting. I could tell you that is not experimentation that feels particularly key to any kind of important biomedical advancement. And I think that kind of information helps clarify for people what animal activists are actually talking about when they criticize institutions that, like I've been mentioning, come into this discourse with a lot of prestige, a lot of respect, and who people are going to defer to unless you give them hard evidence why they shouldn't. And there's little evidence harder or more compelling than actual video.
Yeah, I can offer a few examples. I mean, the beauty of this is that the term record is so broad, right? So don't come at it from this is a paper document. A record could be lots of different things. But as far as examples, we had a cruelty case against the slaughterhouse in Wisconsin and had gotten some records from the USDA, communications between the slaughterhouse and the USDA where they essentially did not dispute what happened, right? Didn't deny any of the facts. And that was helpful when we got to court to say, look, this isn't in dispute. Like, it is clear that they've admitted to doing this. That was useful. We filed a Federal Trade Commission complaint against the country singer Luke Bryan for doing some promotions for the pork industry that compared modern pig farms to a 5-star hotel. We got some records, like internal communications within the pork industry, talking about how influential Luke Bryan was on the public, right? And that supports our case, our argument that you're using this person's influence to kind of deceive the public. When I was at Animal Outlook, shout out to them. I know some of those folks are on this call. We got some records of experiments from North Carolina State University of ventilation shutdown. So 10 hours of videos of individual chickens in plastic boxes being suffocated, subjected to heat stroke, and that information was used for wide public exposure. So there's lots of different ways, right? Whether it's public exposure, whether it's supporting a legal case, I would just kind of use your imagination of what might be out there. Maybe it's the videos Asher talked about, maybe it's email communications, maybe it's procedures, it could be a host of different things.
I wanted to pose a question in live that was actually already answered in the chat and very helpfully by Will, but I'd be interested in Asher's thoughts as well, or any additional thoughts from Will, which is how do your organizations go about identifying entities from which you want to seek records?
Sure. So a lot of that is combing government resources and figuring out what records should exist. I mentioned scouring publications, but also say for the work that PETA does around roadside zoos that involves, looking through the big long list of all of the registered AWA licensed zoos in the country, reading all of the Animal Plant Health Inspection Service inspection records, and figuring out who's being regulated, who has a spotty record, and then anytime you're targeting any kind of entity that is subject to a regulatory process, there's a decent chance that there are government records about them, be they federal records that you can get under FOIA or state records, especially if it's an issue that's been in the press or that it's possible folks have been making law enforcement complaints to. It's a massive boon, especially given that anyone who's been involved in litigation, I'm sure, understands these processes take a while. Even from filing a complaint to completing a motion to dismiss can be many months. It could be a long time until you could take actual discovery. But in the meantime, nothing stops you from submitting state public records requests that can give you a lot of what you'll be looking for later in discovery and can help guide that work.
I would also just agree with everything there. I watch the news a lot, whether that's agriculture industry news or like if you look at the news, there's always stuff happening and you're going to look and stop and say, wow, that's interesting. Who's involved in that might have records? And so I think the news is certainly a key source. And when I say the news, I'm not talking about turn on your local TV, but dive into industry publications, things like that. And then, the other thing is that if you have a case you're working on that involves, XYZ company, I think it's worthwhile to stop and think about what touch points that private company might have with the government in any way, shape, or form, right? Where is there an intersection with a state or federal entity? And if there's an intersection, then there's potentially records there, right? And once you get good at records requests, it can take 2-3 minutes to get one out the door, and then it's a waiting game, right? And it can be like Christmas, right? You never know what you're going to get. Here are the files, boom, you've got something interesting at the expense of a couple minutes. So following the news and then just doing a little bit of brainstorming about, hey, if you've got a private entity that you're interested in, what are the touch points with the government that might have some records, and then going after those.
That makes good sense. With respect to it being a waiting game, are you both seeing like more protracted response times in this administration? Or has it been still kind of business as usual?
I think it's almost too early to tell, just because I think that for animal activists especially, we're all very used to always getting very protracted response schedules. That said, I think that's a consideration as well. If you're thinking about who might be the best person to make a request, we've seen through our public records litigation a lot of arguments made for why some entities might have longer or slower response times. And part of that is sometimes, well, how many requests do you have pending already? So maybe there could be an issue where it helps to have dedicated activists who are submitting their own requests and can help get information out there.
Thank you. So we are basically at time. So I just want to thank you all again, all of our panelists, Will, Asher, and Lisa, for joining us today, and for sharing all of your insights.